Yep. As you saw posted in the chat, please rename yourself with your CISA number, then your first and last name. When you hover over your picture, there will be 3 dots in the upper right-hand corner. When you click on these, you should see rename in the list. If you need your CISA number, please let us know in the chat and we can certainly grab that for you. Welcome to the April session of the Special Education and Pupil Services Leadership Academy. Certainly, these April showers are going to bring us May flowers. We don't doubt that. I'm not sure what it's doing in your area of the state, but here in Green Bay at CISA 7, we are getting those April showers this morning. This morning and all of our academies are brought to you by partnerships between the Wisconsin Regional Special Education Network, or the RSN, the Wisconsin Department of Public Instruction, or the DPI, and the Wisconsin Council of Administrators of Special Services, or WCAS. My name is Rachel Kotarabik. I am the Regional Special Education Network Director, or RSN, for CISA 7. We're excited to have so many of you join us. Our team strives to be inclusive and meet the needs of all of our Wisconsin directors. The intent of these sessions is to provide you with timely and relevant information so you can do your important work in all of our Wisconsin school districts. Some of our meeting expectations. We invite you to turn your camera on if you are able. With this, we ask that you are mindful of your space and surroundings. Please mute your microphone unless you are asking a question. We ask that you use the parking lot to document your questions, and I would ask that my team please just drop that in the chat, and the agenda also would have been dropped in the chat for you. Please use the chat to respond as prompted by the speakers. We ask that you focus your conversations added to the chat for the benefit of the group. We would like to remind you that we have a participant folder for resources that we will update each month. This is linked in your agenda. In addition, there will be follow-up emails that come to you after the session with an agenda that is updated with speaker slides and timestamps of our recording. As I mentioned, we do utilize that parking lot, which is linked to your agenda. If we have any unanswered questions, either in the chat or that have been asked, we will work with our speakers to provide a response. Please include your contact information if you prefer. That way we can get back to you directly. If we are unable to get parking lot questions answered during our session today, we do continue to monitor that document and respond accordingly. If you have a question for one of our experts speaking this morning, we're happy to facilitate getting the question to them and certainly a response posted in a timely manner to that parking lot document. As I mentioned, the agenda is in the chat. Each month, we encourage you to set a goal for yourself for our session. By setting an intention for our learning, we are able to better focus our energy and attention on those pieces of information most applicable to our work. And we're more likely to take the information we receive and apply it back in our districts. We have a full agenda for you this morning. First up, we'll be joined by Rose Kilmurray and Tim Perenboom to talk about comprehensive special education evaluation when considering disability-related needs in reading for students who are deaf and hard of hearing. Then we'll have a brief break and then a timely visit from Seth Bishop regarding racial disproportionality as we anticipate final release tomorrow. Following Seth, Paul Sherman will present on Section 504. Then we'll take another short break, and Jenny Bibler will wrap up our morning with Early Childhood and Indicator 6. I hope everyone has had an opportunity to identify a learning objective or set an intention for their own learning this morning and is sitting in wait with a full cup of coffee. All right, welcome back. I hope you had an enjoyable break. Sorry about the little beep in there. I didn't realize there was a beep at the end of that timer after that nice relaxing music. I hope that wasn't too alerting to anyone. Hopefully you had a chance to grab a cup of coffee, use the restroom, take a walk, whatever fills your cup literally and figuratively during that break. Seth Bishop is now here to share about racial disproportionality. So as he settles into this space, I know he just got let in from the waiting room. But hopefully you all, this is super timely. Hopefully you all are looking forward to his update because tomorrow we anticipate the final release of our JFN packets. and we'll be looking forward to those. And if you have any questions for him, this is super timely and relevant. Seth, are you ready to take the wheel, for lack of a better term?
I am. Can you hear me all right?
I can. Thank you so
All
much.
right. Unfortunately, my headset isn't working this morning, but I'll just stick with computer audio. I'm going to share my screen so you can see a sample version of our racial disproportionality report, and we will walk through its different components, how to interpret some of the visualizations and numbers, and next steps. So, share and give me one moment and I'll make this bigger for you all so you don't have to strain your eyes. All right. Can everyone see my screen all right?
Yep, I can see it on my end.
Excellent. So, uh, disproportionality in special education is something that every state has to evaluate annually using a methodology that is laid out in statute. Uh, Within that methodology, however, states have some discretion to set their minimum cell and n sizes, risk ratios, years of data, etc., um, to make those determinations. Here in Wisconsin, we use a minimum cell of 10, a minimum n or denominator of 30. These are the max allowed by federal law without sort of special request, and a risk ratio of 2, um, which is uh, a common risk ratio used across states. I think it's a little bit below the mean. But it's right in the range of what other states are doing. So, looking at this report on the very first page, you will see a very quick, high level summary of findings, specifically whether or not there was disproportionality or discrepancy found across three categories: identification, that being the rate at which students are identified with a disability or generally or a specific disability; placement, whether or not students are learning in an environment with their non-disabled peers; and discipline, the rate at which students are removed and the length of those removals uh, uh, among students with IEPs. There is a disproportionality and discrepancy for discipline. These are technically different things using completely different metrics. We have done our best to align them as much as we are able to within the bounds of federal regulations, but they are technically different. So you may be found as discrepant, uh, but not disproportionate. And it's theoretically possible to be found disproportionate in discipline, but not discrepant. So just be aware that these are technically two different things with two different methodologies, but both are hopefully informative for you. The main difference for you all is that a finding of significant discrepancy has a lot less, fewer required actions that you'll have to take care of. Um, right below that, you will see a summary section that walks through required actions. So whether or not the student had some sort, or excuse me, the LEA had some form of identification will determine if none are required or not. Um, but basically only these boxes will check if they apply to your LEA. So, uh, whether or not the if an LEA has been found as disproportionate in a previous year but aren't this year, this box would check because they have to spend off the remaining reserved funds. Um, Conducting a root cause analysis, whether or not the LEA is also identified for under LEA determinations is checked. So this is sort of a one-stop shop for what you can expect moving forward with your identification, as well as the dates associated with these tasks. There is also an appendix to this document, I believe, that walks through uh, some of the further required actions. Um, so, comprehensive CEIS required actions timeline. This goes into a little bit more detail, but in terms of a quick view, the required action section should provide you with an overview of what to expect in the coming year. Scrolling down to page 4, this is just a quick blurb I put together about some of the terminology you'll see in this report and how to interpret some of the data visualizations. So a lot's going on in these data visualizations. So I understand it can be overwhelming, but here's a quick rundown. In each of these, you will see a horizontal pink line representing the statewide mean. This is for informational purposes only, um, for LEAs to understand roughly where their different racial demographics fall compared to statewide rates. The statewide rate does not directly affect disproportionality findings. Disproportionality is primarily an internal measure within an LEA comparing the rate at which a particular racial group experiences a negative outcome over the rate at which their peers experience that same outcome. So it's not a comparison across LEAs, it's a comparison within an LEA of what's going on within the different racial demographics of the LEA. If one of these visuals has a solid background, the non-striped background, that indicates that that group met minimum cell and N sizes for that reporting topic, meaning that they theoretically could be identified. The stripe bars indicate that they did not meet cell size in one or more of the years. Um, if Just walking through these as an example, this dark blue stripe background means that American Indian students in this hypothetical example would not have been identified if they did meet cell size because it's solid blue, so not disproportionate. But they also didn't meet cell size. So even if this were the lime green, they wouldn't get an identification. The sort of aqua color here indicates a progress waiver. So in this example, Hispanic or Latinx students met cell size because it's not striped. Um, and they would have been found disproportionate, but for 2 consecutive years, they made progress of 0.25 or more in reducing their risk ratio and thus earned a progress waiver. And when you have a progress waiver, that means that There aren't required actions for you related to that. Um, we assume that uh, the assumption is that if you are decreasing the risk ratio on your own without our oversight or intervention, then our goal is to let you keep doing that. And lastly, this lime green color indicates a finding of disproportionality. So in this instance, the LEA would be cited for disproportionality uh, based on the emotional behavioral disability identifications of Black students. Uh, Note that while risk ratios are what is used to determine racial disproportionality, this is not a data visualization of risk ratios. This is a data visualization of rate uh, across race. So effectively, it's the numerator of the calculation for each of these groups. It is not the full risk ratio. And we chose to do it this way because A, it's more intuitive for stakeholders to grasp, and B, ultimately, in order to improve disproportionality or address disproportionality, uh, what we want to see is an overtime decrease in the rate. Um, a lot goes into racial disproportionality risk ratios. So you may see things, those getting higher instead of smaller, as you begin to address concerns, because any change in the comparison group would also affect the change. So ultimately, at the end of the day, what we want these visualizations to communicate is uh, a uh, a presentation of the higher rate compared to their peers, and to prompt LEAs to think about decreasing those rates over time. Let me pause there real quick for questions, as I just dumped a lot on you all. So I want to make sure that I didn't lose anyone.
Seth, the only question I've seen in the chat so far is where can they get access to this sample report?
The sample report will be uploaded to our website as soon as we're allowed to update our website again. DPI is going through a website freeze right now, and we can't put anything up there until it's over. But the sample report will be made available there. I can also share it with you all if someone if you can't wait. I can make sure that you have a link to this. Um, but yeah, it will be posted on our website eventually.
Thank you. That's
Yeah,
all I've
Seth.
seen for questions so far.
Oh,
All right.
and this is Erin. Seth, hi. If you could share it with me, that would be awesome. And then I can make sure that the group that attended today has access to it, if that's okay.
Sounds good.
Thank you.
All right. Uh, so each of the areas of each of the categories for which we have to evaluate disproportionality have their own section in this report. Identification of students with IEPs is the first one you'll see, and in this hypothetical school district, we see uh, uh, we see that across all the racial demographics, the LEA met the minimum cell size to be identified, um, and did not make sufficient progress to earn any waivers in a single year, let alone across 2 years. However, none of their risk ratios for the last 3 years indicate a finding of disproportionality. Uh, they are uh, Asian students in this hypothetical example are much lower than their peers in identification with a disability. Um, as and While others are a little bit higher than the one that we would hope for, none raised to the level of severity that to result in a disproportionality finding. Um, so here we see the highest among all of them is just a 1.4. So they would have to get up to a 2 and maintain a 2 or higher for 3 consecutive years before identifying. And here you'll see this
Sure.
visualization aggregates all those years together, so it's a little bit different in that way, but it at least shows, okay, um, the Pacific Islanders who were represented in this data do have a higher group percent than their peers, and considerably higher than the statewide average. So that would indicate why that risk ratio is higher, but still doesn't rise to the level that would result in an identification. Looking at across specific categories, however, we do see at least one identification that this hypothetical LEA experienced. So, for intellectual disabilities, it appears that Indigenous students met cell size for all 3 years. They made progress 1 year, but we need at least 2 years of progress in order to earn a progress waiver. And their risk ratios are consistently above 2.0. So in 2024, it was 3.48. In 2025, it was 4.02. And in 2026, it was 2.78. So uh, this would rise to the level of a disproportionality finding. However, just because that is the only official finding doesn't mean that there isn't meaningful work that could still be done here elsewhere. So here we see again, Pacific Islander students are consistently much higher than their peers, even if they aren't rising to the level of meeting the minimum cell or N size to have a formal identification. Um, this would signal to me that, you know, something concerning is happening. And perhaps before that group moves into identification, we can do something to start addressing these higher rates among Pacific Islander students across these different disability reporting categories. So even though their only official finding is Indigenous for intellectual disabilities, uh, Pacific Islanders also have some area, uh, uh, the LEA has some area for improvement here, and we would encourage that LEA to begin thinking about what's going on and how they might address it, despite the fact that there is no formal identification. Moving on to placement, again, uh, we see uh, most groups met minimum seller N across years, except for Pacific Islanders. But that failed where it did not rise to the level of disproportionality. So interestingly, uh, Asian students are have a higher risk ratio than their peers, and it's getting pretty close to 2.0, at least in 2024, but isn't there yet. So until it reaches 2.0 consistently, they wouldn't be identified. But again, we see the same concern around Pacific Islander students in this hypothetical scenario. Now, this can be the result of a small n, so it's, you don't necessarily want to hang your hat on it, but the fact that the student group keeps coming up in this report, despite not being formally identified, would hopefully raise some concerns locally so they can start thinking about what's going on here. And lastly, there will be a section for discipline, which has the exact same format as all the others, so I won't spend more time talking about it. But whenever you see a student group highlighted in this lime green, that indicates a finding of disproportionality for that racial group and reporting category. So here, there are findings of disproportionality for Black students in all disciplinary removals, out of school removals greater than 10 days, and out of school removals less than 10 days. Um, and that is again represented in the report. Uh, so that is a very quick rundown of racial disproportionality, but we're not quite done because discrepancy is still something. So discrepancy looks at the same base data as out of school removals greater than 10 days. So this last category here. Um, However, it calculates it a little bit differently using a risk rate instead of a risk ratio. And unlike disproportionality, which is primarily an internal measure within LEAs, significant discrepancy is explicitly an external measure. It is comparing to statewide rates. Um, uh, Also of note is, while disproportionality uses 3 years of data, the max number of years we're allowed to use for discrepancy is 2 years. So here you'll only see a max of 2 in this field. And what we see is that across all students with IEPs, as well as in Black, Indigenous, and multiracial categories, we are seeing signs of significant discrepancy. Uh, this measure, I will say, because of the limitations of federal regulations, is not as robust of a finding as a disproportionality finding. There is no minimum cell size. There is still a minimum N of 30. So theoretically, a very small district could experience this with a single student if it happened 2 consecutive years. Um, However, uh, that is not the primary instance in which we see this. We're more likely to see this when there is some form of problem, even if it does not rise to the threshold of disproportionality. So just something to keep in mind when looking at this data is, although it uses a smaller cell size and fewer years, don't just write this off as being, oh, whatever, uh, like not a concern. It can be a canary in the coal mine uh, for LEAs. So I encourage all LEAs, if they have a significant discrepancy finding, to take it seriously and to do the associated required actions, and to keep an eye on it, even if, I don't encourage you to lose sleep over it, but I do encourage you to think about it in your waking hours. And the last bit here is the appendix with the required actions timeline. Um, this will walk you through what's expected of you and when over the coming year. And at the final end of the page, just for the convenience of folks, there's a quick table summarizing the findings of disproportionality and discrepancy across all different groups. So um, just a sort of last minute addition that I think we added last year for our DPI staff who want to be able to just scroll down to the bottom and see a quick snapshot of what's going on. That's all I got.
So
Any?
there are two questions in the chat.
Okay, perfect.
One I think has been addressed. Somebody was just asking if the report will be in the SAFE portal and if it's available now, but I believe the anticipated release is tomorrow.
Yep.
And then the other question, could you remind us where the counts are pulled from for these reports? Is it from the December count?
It is from the snapshot taken in December, but that snapshot includes data from uh, third Friday of September, October 1st, and year-end completion of the previous school year. So discipline data, for example, would be year-end data. So for that, that's coming from the previous. So that data is lagged 1 year, but it all comes from the December snapshot. Any other questions?
Yes, I still want to know if it's found in the safe file exchange on the DPI website,
Yes.
net portal.
Yeah.
And then it doesn't show anything. I'm in there right now. It doesn't show anything historical. Yeah, I've been the director here for 25 years. We have been like 8, 9 years ago. I don't even see the report from 8, 9 years ago. Are you able to access historical reports somewhere?
You should be able to in safe. I'm not sure why it's not showing up right now. It may have something to do with the impending release.
Aha,
Um,
okay. Perfect.
but yeah, historical reports are, we generally don't take anything down from there.
Okay.
So yeah, I'm guessing that is why it's not showing up right now is because a release is about to be pushed.
That's helpful because I was looking for the box with a little green label that was around disproportionality and it seems to have disappeared. And I thought, ooh, I was going to follow along with an older report with what you're saying. So that's helpful.
Yes, so to answer your question, Lenora, you will not see your current year until hopefully tomorrow when release happens.
Yep, they did answer me.
What's that, Paula?
Oh, I'm sorry, I didn't mean to have my volume on. Oh no,
That's okay.
not you, someone else, sorry.
Anything else coming up for folks?
I've been toggling between the parking lot and trying to watch the chat. I am not seeing anything in the parking lot. And I think you've been keeping up with the chat. So I think we're good to go and we are right on time. That being said, if folks have other questions, feel free to drop it in the parking lot and we can certainly get in touch with Seth. Thank you so much. Definitely very timely with release anticipated for tomorrow. Seth, we appreciate you joining us. And if you could, like Erin said, share that sample report with her, we would very much appreciate it. But now I think we get to switch gears and head over to section 504 with Paul Sherman. So thanks again, Seth, for joining us. And hopefully Paul is on. And I think for those of you on the call, we're going to switch and move over to section 504. So Paul,
I
If
am
you
here,
are with
Rachel. Can you
us,
hear me?
there you are. There you are.
Yep.
I'm going to hand things over to you and let you take control if you have slides to share, which I think I saw uploaded already. The
I
screen
do.
is yours. Welcome to the space, section 504.
Thank you. And let's see. I hope you can see my slides.
We can see your slides. They are not in. There you go.
There
There
we
you
go.
go. Now you're in presenter view. It looks great on my end.
Okay, good. Thank you. Well, it's good to be here with you all this morning. I see a lot of names I know out there, so I think we've got some old pros as well as some new learners with us today. So it's good to be here. Um, I did this presentation to the Academy just about this time last year. And of course, at that point, we were just a little ways into the new Trump administration, and there was lots of rumblings going on about the future of the U.S. Department of Education, um, which in Wisconsin, we've always sort of viewed as the main source of authority for Section 504 questions for us. And they handled all the complaints, and we would refer parents and districts there um, to their guidance. And at that point, it was not exactly clear what was going to happen. Um, uh, we do know that the department at this point in 2026, a year later, is greatly diminished. And it seems to be, kind of limping along with its idea responsibilities. The Office of Civil Rights at the U.S. Department of Education, which was the main office responsible for Section 504, has really been decimated. It's getting more and more difficult on the Department of Education's website to actually find out where we go for assistance, where we go for questions about 504. For a while there, it looked like, we used to deal with the office in Chicago. That's gone. And for a while there, it looked like we were being, directed to the Denver office for questions arising out of Wisconsin. I'm not even so sure that the website is putting us in that direction anymore. And of course, what we're hearing from the news is that what OCR is really concerned with these days are uh, matters of transgender issues, not generally on the side of transgender people. And I just saw a news report within the last couple of days that OCR, U.S. Department of Education, is actually bailing on um, resolution agreements they had with districts over the past several years to resolve some of those complaints about gender identity discrimination, and they're just not even going to enforce those agreements anymore. So that's clearly what they're concerned about. I think they are not so concerned about 504 plans for students in K-12 schools. So we're just kind of hanging out here, trying to operate based on what the old rules were. They haven't put out any new rules about 504, any new guidance. Um, some of the guidance about 504 is still posted on the U.S. Department of Education's website, so I think it's still reasonable when we have questions to rely on that guidance. And in the meantime, we're just going to use our common sense. Um, Nobody's told us at the federal level that, well, we're not going to do this anymore, so we're going to leave this up to the states to enforce 504. We haven't gotten that word yet either. So um, things are worse than they were a year ago. But still, we don't have a lot of clarity as to what the federal expectations are for us when it comes to 504. So that just kind of where we're at the moment. I'm certainly not going to tell you you don't need to pay attention to 504 anymore. And in fact, Patty Williams and I were just having a discussion the other day that we're still seeing um, that we're still seeing IEPs where it looks like maybe it would have been better for the student to have a 504. And that indicates to me that maybe there are some students out there who need some additional assistance in school and might benefit from having a 504 plan. So in that sense, we certainly don't want to ignore 504. Perry Zerkel did a survey several years ago now, in which he found like Wisconsin overall, in terms of the number of students who have 504 plans, is like, second, we're like number 49. There's only one state below us that has smaller number of students with 504 plans. Um, we may look at that as a positive and say, well, we're doing really well with our IEPs, and we're meeting students' needs through the IDEA process and IDEA regulations. But it's worth questioning, I think, why we're so low on that, so much lower than all the other states in the country in terms of our utilization of 504 plans. So my presentation today is because we're probably all generally pretty familiar with the IDEA requirements. I'm just going to do a little comparison between 504 and IDEA to sort of illustrate, I think, how 504 works. And I'll point out some interesting little quirks about 504 as we go along here. So eligibility, right? We know under IDEA, a student needs to meet criteria in one or more of the eligibility categories, and they're in need of special education, right? And we generally think about that as specially designed instruction. So a student might meet the eligibility criteria, but not need that specially designed instruction. And that would mean under IDEA, that student is not an IDEA eligible student, is not going to have an IEP developed. Okay. The eligibility criteria for 504 is much broader. Basically, does the student have a physical or mental impairment that substantially limits one or more major life activities? And major life activities are, breathing, eating, drinking, walking, sleeping, and also in that list are things like learning and reading. So that's kind of where the whole 504 eligibility it substantially limits one or more major life activities in the school aspect, right? So it's pretty common for us to think of the difference between IDEA and 504 is that need for it's not the general rule, but we do need to be aware, right? 504 as a law is older than IDEA. And it was really the first attempt to make sure that people with disabilities were, getting a fair opportunity at education along with their non-disabled peers. And the 504 regulations actually use the word um, the concept of FAPE is in 504, as well as the notion that specially designed instruction is something that can be provided through 504. So we at least need to be aware of that it's not strictly the need for special education that separates IDEA and 504, although that's the general rule, right? And we need to recognize that also separating them is those very specific eligibility categories that we have in IDEA, as opposed to the broader, right, just physical or mental impairment that substantially limits one or more major life activities. The reason I bring this up is because 15 years ago now, maybe we had a case down in the southeastern corner of the state where the parents were absolutely opposed to having their child be IDEA eligible and have an IEP, right? They were, in their mind, that was labeling their student and that was inappropriate. And the district said, well, you have therefore declined IDEA eligibility, and we don't need to do a 504 plan for you. And what OCR told us and told the school district at that point was that that argument doesn't wash, right? That the parent can decline IDEA services, revoke consent or refuse to provide initial consent for services, and still be eligible for a 504 plan. And district, you have to have a 504 plan in place for that student, and the 504 plan has to meet all of the students' needs, including the need for specially designed instruction. Okay, right. So that's a weird corner of this interaction between IDEA and 504, but I think it helps to be aware of it at least to kind of understand what's going on here. So that parent got the 504 plan, which essentially looked like an IEP in the end. With the 504 eligibility, there's some restrictions in there about the physical or mental impairment not being caused by alcohol or drug abuse, which really isn't all that relevant probably for most of the kids that we're working with. And that sometimes this question comes up, well, what about like intermittent disabilities? The student broke their leg and they're going to be in a cast for 6 weeks. Is that a disability that qualifies, or is that a physical impairment that qualifies the student for eligibility under 504? Think about that a little bit in terms of the practicality of the situation, right? The student is in a cast for 6 weeks. Is there really going to be any question that in your district that's going to mean the student might get extra time to go between classes without being counted as tardy? That maybe they're going to have access to the elevator that maybe they normally wouldn't have access to. Maybe we're going to send somebody along with them from class to class to make sure that they can get around okay, right? All that by way of saying that, the issue of a 504 probably is not going to even come up in that type of situation because you're just going to naturally accommodate what the student's needs are at that point. Technically, is the student temporarily disabled and maybe in need of a 504 plan? Yes, but it's probably not going to come up in that context as a 504 plan. So there's some guidance laying around out there about temporary disabilities and how it all fits in there. And if you've got a specific situation where you're wondering about that, you can certainly give me a call and I can probably help you find where that guidance is. We can sort something out around that. So. All right, evaluation, right? We're all familiar with the IDEA evaluation process. That's done by the individualized education program team. We know through the IDEA regulations that the team has to include a regular ed teacher, special ed teacher, parents, LEA representative, people who can interpret the results of assessments, all that good stuff. We know that there's a timeline, the 60-day timeline for the evaluation. We have to do a review of existing data. All that kind of thing is what needs to be done in order to make that evaluation valid under IDEA. 504, the regulations say, well, the evaluation is conducted by a group of persons with knowledge about the student. Okay. So what does that mean? Well, just what it says. The guidance that that OCR put out a long time ago said, well, basically, if you're following your IDEA policies and procedures for doing an evaluation, and you're calling it a 504 evaluation, you're doing what we expect you to do. So when you assemble a 504 evaluation team, should you have a parent? Yes. Would it be a good idea to have a regular educator? Yes. Would it be a good idea to have somebody who can commit the district's resources? Yes. Is it a good idea to have somebody who's can interpret the results of assessments? Yes, right? right? So if you're following, generally following your procedures, your IDEA procedures as appropriate to the situation, you'll very likely be meeting the 504 requirements for conducting an evaluation. You do want to do assessments if they're necessary. You want to review information provided by the parents, and in the case of 504, it's likely the parent's going to be bringing you some medical information. As with IDEA, I think it's a good idea if the 504 evaluation team thinks additional information is necessary, that the district arrange and pay for getting that information, whether it be in the form of some sort of medical evaluation or some testing that the school psychologist is going to do, right? Those are all things that, a la IDEA, you're going to want to be following with the 504. Is there a timeline? Not really. What would a reasonable timeline be? I think OCR in the past would have told us it would be 60 days to complete the evaluation. Okay. Services, and here I use that FAPE term, right, which we very clearly identify with IDEA. That's the special education and related services as specified by the student's IEP team. Right. The 504 regulations say it's appropriate educational services designed to meet the needs of the student to the same extent as the school meets the needs of students who are not disabled. So, we don't directly make that comparison when we're talking about IEPs, but that's kind of what all the regulations around IEP, the procedures, the requirements for what goes in the IEP document, that's kind of what it's aiming for, I think, is that we're meeting the needs of the student to the same extent the school meets the needs of students who are not disabled. Maybe in 504, it's a little bit, I think under IDEA, we might say, well, you might, you may be needing to do a little better job of meeting the needs of the students with the IEPs than you do with the students who are not disabled. Maybe under 504, that's a little bit looser, and we're just, thinking more about access, right? But notice that word again, educational services, right? Does that include specially designed instruction? Potentially, although very likely you're already meeting the needs of those students who have IEPs by providing that specially designed instruction. So interestingly, 504 plans don't actually need to be a written document, right? At the end of the evaluation process, if the 504 team finds that the student is eligible and needs those educational services, there can just be a verbal plan as to how that student's needs will be met. And OCR in the past would have said, yeah, we don't need to see a written document. But of course, compliance people like me and probably your school attorneys would say, well, we'd really like you to write out a 504 plan. And so that if any question arises about whether that student's needs are being met, we can look at the plan and actually see what the team agreed the student needs, and we can verify that what the student needs is actually being provided because it's written down in a plan. DPI does not publish model forms for 504 plans or 504 evaluations, and neither to this point has OCR. I think, maybe some of your vendors at this point for your IEP software might have provided some sample documents for 504 plans. There may be, just some floating around out there. I know that some districts just use their IEP paperwork, and in the old days, before that was all electronic, they would just cross out IEP at the top of the page and write in 504 plan. That's all perfectly acceptable. Um, like I say, the important part is that just, you have some clear documentation about what the students' needs are and what the plans are to meet those needs so that the plan can be implemented. So it's really kind of up to you on a district by district basis, what documentation you're going to create around the services of the 504 plan. Okay. I guess I've kind of talked about this, right? The plan goes down in the IEP or in that 504 plan. Okay. Reevaluation under IDEA is required every 3 years, as you know, unless the parent and the district agree to waive the reevaluation. 504 regulation just says periodically, right? Again, would it be reasonable for periodically to mean every 3 years? OCR would say yes, it would. But there might be a reason, depending on the student's disability, of course, why you might want to do that more frequently if things are changing for the student, or potentially you could go a little bit longer than 3 years when doing a reevaluation under the 504. Dispute resolution is another interesting difference here, and it's an important one, and I think a lot of districts don't understand their obligations here, right? So under IDEA, we have the mediation system that's available to you. We have the state complaint process, and we've got the due process hearing requests. That's all laid out in state and federal special education. Lots of language, lots of steps, lots of resources available, right? The 504 regulations say that the district has to have a grievance process in place. So, technically in your policies and procedures handbook that your board has adopted, there should be a 504 grievance procedure in there. What that procedure looks like, nobody really specifies, right? You would assume it would be an opportunity for the parent or the student to raise a concern about either an evaluation or the development of the 504 plan or the implementation of the 504 plan, and then a process for having that sorted out by maybe somebody who didn't have anything to do with the original situation. But so grievance might be, equivalent to the state IDEA complaint process, except you need to handle that internally. You can't take that to OCR, the parents can't take that to OCR, and you can't take it to DPI to have us resolve that for you. The other really weird thing is that 504 says you have to have a due process system in place locally, right? You can't use the IDEA due process system to provide 504 due process resolutions for parents. So if a parent insists on a due process hearing under 504, the district actually has to go out and find a neutral hearing officer to conduct that hearing and render a decision. How you go about doing that is something definitely, if you get that request, you're going to want to be talking to your own district legal counsel about that and how you go about figuring that out. In the past, right, we would say, okay, parents, you and the district are in a disagreement. You need to contact the Office of Civil Rights to file a complaint about that. I don't think Office of Civil Rights at U.S. Department of Education is in any way capable of taking on 504 complaints at this point. I don't even know what would happen if a parent tried to contact them and say that. Likely they would say, have you used the district's grievance process yet? Have you asked about a due process hearing arranged for by the district as a way of resolving that? Probably OCR would have said that in the past, although they would have probably also done some, work to help both the district and the parents understand what that all meant, kind of what the limits of the responsibility were. But that's really, I think, not a practical option at this point. It's to go to OCR and try to get some assistance with dispute resolution on 504s. Private school students, right? Child fine and evaluation under idea is the same, right? So we have the same obligation to locate, identify, and evaluate students attending private schools as we do for our students who are attending the public schools, okay? Students in private schools under IDEA are entitled to equitable services, not FAPE, and we provide those equitable services to students who need those services through a service plan developed using the IEP process, but it's not an IEP, right? So we only are specifying the equitable services that are going to be provided. The dispute resolution, excuse me, for 504, right? What do you do? That while there's no equitable services under 504, because there's no funding associated with 504, right? And you all get your Part B grants to do IDEA services in your district, as little of funding as that amounts to. And that's why there's that equitable services requirement. Set some of that money aside and use it on the private school students. But there's no money flowing into your districts associated with 504. So there is no equitable service requirement. Right? So the question kind of becomes, well, what is the 504 responsibility for private school students? And I've asked OCR about that in the past, and they really can't. We're never able to explain that to my satisfaction. The only thing that they were able to tell me that I think I gleaned from them was that if a parent comes to you and they're a parentally placed private school student, and they say, we'd like a 504 evaluation, okay, that sort of along the lines of a parent coming to you with the idea that they'd like an offer of FAPE, they'd like an IEP so that they could consider whether they would enroll in the public school or whether they want to stay in the private school. That there might be a similar obligation under 504. So if the parent comes and says, we'd like a 504 evaluation, you'd likely be well advised to just go ahead and conduct that 504 evaluation. The 504 team determining whether the student has a impairment that substantially impacts one or more major life activities. And then you would develop a 504 plan. But like when you develop an IEP under IDEA, you would be developing that 504 plan as if the student was going to enroll in the public school, right? So you're not developing the 504 plan to be implemented at the private school. Now, why any parent would want that, I'm not sure. But I guess if you're asked, it would be best to just honor that request, do an eligibility determination, and develop that 504 plan as if the student were going to enroll in the public school. And then, the private school has no obligation to implement a 504 plan, and you wouldn't have any obligation to provide any equitable services to that student as a result of a 504 plan. Okay. Again, with the private school students under IDEA, we have that state that we have the dispute resolution options available, but due process for child find only. Okay. All right, so like I just said, that for the private school students under 504, no equitable services, but you do probably have some sort of child find obligation to do 504 evaluations if requested. Okay. For home-based education students, no FAPE or equitable services, child find evaluation applies. 504 applies to those students only if they're participating in a public school program and only to the extent they're participating in that program. So if I think we still have that program where the homeschool students can participate in up to 2 classes in a school district during a school year, right? Those students don't have FAPE responsibility attached to them, right? They're in your school for those 2 classes. That doesn't mean you need to develop IEPs for them for those 2 classes. But 504 would apply to students who are participating in those 2 classes. So if the student has a disability, it's important that they get evaluated for 504 eligibility, and we have a 504 plan developed for them to be implemented only when they're participating in that limited public school program. 504 discipline, we need to remember that the discipline protections and IDEA do apply to students who are on 504 plans. That again, that's that guidance we got from OCR. Therefore, you do need to remember that a manifestation determination is required for changes in placement for students who you have on 504 plans. So if you're going to expel a student, you have to do a manifestation determination under 504 before you expel the student. And if you find it was a manifestation, just like with your IDEA students, you cannot expel the student unless the parent agrees otherwise. The difference between IDEA and 504 in terms of discipline is if you find that it's not a manifestation of the student's disability and you go ahead and you expel the student, there is no FAPE requirement for those expelled students who are 504 students, right? So you all know under IDEA, we have to continue providing programming for IDEA eligible students who are expelled so that they can meet their IEP goals and make progress in the general curriculum. That is not the case for an expelled student who had a 504 plan. At that point, they're just like a non-disabled student who's been expelled, and they'll have to figure out how their education will continue unless your district happens to offer a general program of special education or continuing education for expelled students. There is here linked on this slide the discipline guidance that came out several years ago. It's still posted on the Department of Education website, so I assume that they would still think that we need to follow that guidance. Last thing I want to talk about is we need to remember that 504 is also a non-discrimination law, right? That's no qualified handicapped person shall be on the basis of handicap, be excluded from participation in, be denied the benefits of, or otherwise be subjected to discrimination under any program or activity which receives federal financial assistance. And all of you are in programs which receive federal financial assistance. So we can't discriminate against students with disabilities as defined under 504. You know, we can't make rules which say this is not for disabled students, and we do need to make accommodations for students with disabilities. This most frequently crops up right in the field trip situations where you know, the 8th grade is going on a field trip to Washington, D.C. this spring. And we say, well, you can't go because your behavior is not under control or whatever it happens to be. You need to remember that you can't exclude that student from that trip because of their disability. You got to be very careful about things like that. And that 504 obligation not to discriminate also might actually put some affirmative obligations on you to provide services in those extracurriculars or field trips or the like so that the student can um, participate. There is language in the 504 regulations, which I wanted to point out. This relates to the non-discrimination aspects of 504, right? So um, disability is not only having a mental or physical impairment that impacts one or more major life activities, but it's also for purposes of non-discrimination aspects of 504. It's defined as having a record of such impairment or regarded as having such an impairment, right? So the student might not actually have a disability, but in cases of harassment or making decisions about who and who cannot participate, if we're perceiving that they have a disability and we're excluding them based on those perceptions, that's a type of discrimination that's prohibited. Just want to make clear for you that having a record or is regarded as having impairment is not the kind of eligibility that gets you a 504 plan. It's the kind of eligibility that protects you from discrimination. So we don't say that a student has a 504 plan just because they have a record of impairments or they're regarded as having impairments. In order to have the 504 plan, you actually have to have the impairment. Right. So the 504 regulations are linked here. They're at 34 CFR 104. And OCR still has their frequently asked questions document posted on their website. This is the document that I always share with parents when they have questions about 504, and I always share it with school districts when they have questions about 504. It's really kind of the Bible, so to speak, when it comes to the information that we have these days about 504. And because it's still posted, I'm assuming they're still expecting us to comply with that guidance. So that if you don't have that one printed out and stored in a binder on your desk, I really recommend that you do that. It'll be a help to you, and you can also share it with parents when they have 504 questions. Okay, so you can contact me if you want to talk about 504 questions. I'm happy to do my best to help us navigate through this situation. You can certainly try the Office for Civil Rights. Like I say, I'm not entirely sure that they're going to be very helpful these days, but it might be worth a try. So I think that's the end of my presentation. And with that, I'll stop sharing my screen here and take any questions that might have come up or are coming up.
Well, Paul, I think that you are a hot topic today. You have definitely filled the parking lot with a bunch of
Okay.
questions in the chat. So I'll kind of start from the top and see how
Sure.
many we can get through.
Okay.
Certainly, whatever we don't get through, we can send your way and you can just respond to and we can share out with the group.
Yep, happy
So
to
you
do it.
spoke to this one a little bit regarding 504 and manifestation determination, but the question is in the chat. If a student with a health condition or disability is a student with a health condition or disability still protected under 504 if they haven't been first evaluated specifically protections related to manifestation determination?
Well, that's a chicken and egg kind of question, right? I think the first part of the answer is no. The second part of the answer is if you suspect the student might be 504 eligible, it would be I think it's part of your um, child find obligation to do an evaluation if that becomes a question, right? Or if the parent raises that, kind of prior to the expulsion. I would view that as you should be thinking about that the same way you think about um, the idea process we use when um, discipline arises and somebody raises a question about the student potentially having a disability, right? You want to expedite the evaluation and, do the manifestation determination thing the best you can at that point. If it comes up, way later, like kind of there was no deemed to know, nobody raised the issue, there was no reason to suspect the student has a disability. If it comes after the expulsion, do you need to do a 504 evaluation at that point? No, because I don't think you'd need to undo the expulsion, and also the student's not really entitled to any services at that point under the 504. There's no FAPE once you're expelled. Um, so you do need to be aware of it. If there's a suspicion that the student might be disabled and be 504 eligible, then I think that needs to become part of the discipline process.
So a little bit
Can I
more
ask
on
a
the
follow-up? Can I ask a
oh,
follow-up to that one? Because I posted that one in the question. Or like we see a lot of that, families contacting us with maybe a student with ADHD where the impulsivity led to behaviors that led to discipline and expulsion, or concussions where it's led to expulsion, and the families haven't known their rights. Um, so then students haven't been evaluated to determine eligibility under either 504 or IEP,
Mhm.
and they're being, expelled from school. So then, if families don't know their rights, because you don't get
Mhm.
your rights unless you know that you could make that referral, um, what is the legality and the actions for families to protect them?
Um, well, right. So IDEA puts out those very specific deemed to know requirements about when the discipline protections apply, right? Um, and do those directly apply to 504? I'm not sure what OCR would say about that, but the eh, what do families do if they don't know? I don't. There might be some,
One
kind
of the
of
things that we
litigation remedies that you could do with that, but I don't think there's any administrative remedies for families who don't know about their rights.
how does
Uh,
that
you,
how does that though under IDEA,
mhm,
like if there is a pattern of behavior that's been raised to the level of a supervisor,
mhm,
that should be trigger child find, um, or it can trigger, or if a family has concerned or
mhm,
identified concerns,
right,
we have some athletes that, like, the concussion happens on the field in front of the school. Like, there's that understanding that there's something going on, but then um, I don't know. Those are just some of the calls we get from
sure, yeah,
families,
yeah,
and I
and
think
I
that the
and I
families
don't
then
want to,
are stuck, and their child's not receiving education.
right. Yeah, and I don't want to, I don't want to sound callous, right? But I think stuck is the right word. That's just an unfortunate set of facts that the the current 504 regulations don't provide a remedy for that I'm aware of, right? And also please remember that I don't have the final say on how 504 works. That's still
Right.
that federal responsibility, which they've dropped the ball on. So um, I agree that's not a good situation, but I really can't. I'm not. Nothing's coming to my mind about how that gets remedied, really. So
So a follow-up, kind of related to behavior. Does a student with a 504 need an FBA in a manifestation determination?
say that again.
Does a student with a 504
Hmm.
need a FBA in a manifestation determination?
Do they need an FBA as part of a manifestation determination? Is that the question?
I think that's
Yeah.
what this
Okay.
is
Um,
asking. Yeah.
that again, I think would be one of those situations where OCR would say, follow your idea, right? What you would, your idea procedures, which would say if you do, there hasn't been one done, you need to do a functional behavioral assessment as part of the manifestation determination process. I think that would be a good idea. If you neglected to do that, what would OCR say about that? I can't say.
All right. We are at time, but I don't know if you want to just take a minute to speak to this one regarding SDI. So you made a comment about providing services, including SDI, for students with a 504 plan. And this person is saying, I had the understanding that students with a 504 could not receive SDI. You mentioned that case, though. What are your recommendations as to how we should understand guidance on SDI specifically?
Right. So that, like I said, that's a strange little corner of this intersection between IDEA and 504 that I just wanted you to be aware of. I think 99% of the time, right, students who need specially designed instruction are going to have an IEP because they've met criteria and they've been found to need specially designed instruction, so they're going to need an IEP. For your students who have not met the criteria, they're not IDEA eligible, but they do have, they've got the physical or mental impairment, so they're 504 eligible. I just want you to be aware that you may offer specially designed instruction to the 504 students, right? If it's needed. And that's going to be a really small group of students, and not every 504 plan needs to include specially designed instruction. A 504 plan, that's the kind of you're right in that sense, that distinguishes the two. But just don't ignore it if the 504 team really recognizes that as a need and the student didn't meet the IDEA eligibility requirement. So.
Well, thank you, Paul. Certainly, it seems like, I think we've invited you several times to speak on 504, and it just continues to be a necessary topic, right? A lot of questions. It seems to be a gray area. We want to give kids what they need, but we don't always know what that should look like in black and white. But we appreciate you joining us this morning. There are a few other questions in our parking lot, so I will have Aaron probably follow up with you regarding getting some answers to those, and then we can share it out with the group. But for those of you in the group, we're going to take a short break and then come back with Jenny Bibler. So thanks again, Paul. We appreciate you joining us and for all of the great information and resources. And for those of you again in the call, we are going to take a short break. We will return about 11:25 for Jenny Bibler. I apologize to all of you that were like, music was stopped awkwardly early, but my daughter would have said to me, Mom, you need to stop it at an even number. So I had to stop it at the even 5 minutes, because if I have the TV like at volume 25, she'd be like, it needs to be at 26, or the radio at volume 17, she will turn it up to 18. So my daughter's one of those people that like things need to be at an even number. So when it was counting down, I was like, I better stop it at an even 5 minutes. That was my daughter's voice in my head. So I don't know if any of you have a son or daughter that would say things like that to you, but that was my daughter's voice in my head going, Mom, you better stop that at an even number. Therefore, we had that little bit of an awkward pause. But welcome back. I hope you enjoyed your little bit of a stretch break. Or taking care of yourselves. We are wrapping up our morning this morning, which has been absolutely jam-packed with wonderful information and presenters, with Jenny Bibler on early childhood and indicators 6. So Jenny, welcome to the space. If you are wanting to share screen, the space is yours. If you are just having a conversation, the mic is yours. Welcome to our space.
Thank you, Rachel. Good to see everybody. I was laughing when you said that about the music. I was looking down, and all of a sudden I thought, oh no, did I get disconnected? I was quick checking, and thank goodness when I saw it, yes. Yes, hi everybody. It's great to see all of you. When I saw all the names pop up, hang on just a second. I am going to do a share screen. And And let's get this thing in the right. Okay, hang on just a second. Driving and talking this are always a challenge. Okay, hang on. Okay. Oh, wait, hang on. I can't reach this. Oh, shoot, hang on. There it is, slideshow. Actually, you know what? Hang on, everybody. I am so sorry. This is too many. Let me get this in the right mode. Oh, shoot. Okay, I'm going to try this one more time. Hang on. Okay. I want to make sure this is in the right mode. Sorry about this. It's been. Okay, come on. I am having some technical difficulties pulling this PowerPoint up. Hang on. I am so sorry. Oh, okay. And for some reason, the whole thing just disappeared. And I had it all up ready to go.
If it helps you, Jenny, I can share screen for you. You would just have to tell me when to advance slides.
Yeah. Could you do that, Rachel? That would be great. Do you have it?
I think so.
Oh, that'd be great. There it is. Much faster. Thank you. Anyway, hi, welcome to Indicator 6, everybody. Go ahead, Rachel, everybody. Jenny Bibler. Like I said, know everybody. One of the things about Indicator 6, I did want to say this. It's been, I call it recently, in the last couple of years, of course, added to the LEA determinations, which I think has brought new life for us that do work in this area around early childhood special education, particularly on preschool environments. And I think my early learning technical assistance implementation team and I have noticed just again, an awareness by special ed directors that we are so appreciative of. So thank you. Indicator 6, everybody knows, measures the educational environment of children with IEPs ages 3 through 5, focusing on placement in regular early childhood programs, separate special education settings, and home-based services. It tracks here's the big part of this, everybody. It tracks the progress towards least restrictive environment goals. So I really want to bring, I think, the definition of this indicator. There's a lot of misinterpretation about it. To life. And that's that part about the progress towards the goals through that least restrictive environment. One thing real quick about this, again, like IDEA, all of our indicators are age-based. They are not grade level based. So you heard me say ages 3 through 5, and this is no matter if they're in 4K, if they're it's not determined by a grade level. It's truly determined by an age level. So just remember that piece too. Wherever a child is, that is 3, 4, or 5 with an IEP. Go ahead, Rachel. And we do the measurement. So we have three reporting categories: our regular early childhood program, and these are our children attending a regular early childhood program. And I'm going to talk about this and piece in a different slide about the differences between indicator 5 and 6 that are receiving the majority of their special education and related services in that setting. Of course, we have our 6B, which is our special education setting. Like our indicator 5, these are children in separate classes. They are separate schools. They are residential facilities. And then, of course, our 6C is our home-based setting, not to be confused, everybody, with homeschooling. That would be for our children who have reached the compulsory mandated school attendance age. And that is another discussion for another time. So just remember that. I do want to say, when you look at 6A, so these are the 3 categories. When we take your percentages and we aggregate them to come up with our state percentage, which you are all familiar with, and I have those in another slide coming up around for our state performance plan. 6A is all that is being reported through the IDEA determination. So really that is what our goal is around your determinations, is that 6A piece. So just remember that even though we look at 6B and we report that, we're really focusing on the positive, and that's making sure that the majority of those special education services are provided in a regular early childhood program. I quickly want to define what that is. In federal law, in our federal piece, we have 6A, and that regular early child program is defined at the federal level as public 4K or public school, public early childhood. So that would be a public 4-year-old program. We have a private preschool. It could be a private preschool, Head Start, and child care. So do know that those are what we call regular early childhood education settings. So that's good to know. Okay. Go ahead, Rachel. Thanks. And here we have these targets. And these, of course, I think it's really important, and I kind of blew these up a little bit, are those state targets. And again, all of your local targets or your local percentages that you come up with when you're putting the codes and you're doing the formulas, they're put together to come up with our state target. And this is what you're being measured on, of course, is in these categories, especially 6A is this district reaching or exceeding the state target of 38.3% of the children in the state of Wisconsin who have an IEP who are receiving the majority of their special education services in that regular education program. So if you think of 38%, everybody, and you think about that at the local level, that's 30, if you have 3 kids, you say to yourself, can one of our children, but that's all we need. Can we really look and think about, could one child be receiving the majority of their services? So think about that when we look at that piece around that 38%. And then, of course, you can see our targets for our children in special education separate settings, and the children that we're looking at around the target of the children receiving their services in the home at just almost 3%. So we'll talk that. I think that 38% becomes a really important number here. Okay. Next slide. I talked about the determinations. Again, 6A, 6B, and 6C are percentages that are reported to the state, but for IDEA determinations, you will see that on your report as just the 6A piece. So again, that DPI aggregates these percentages, and that's what reported to the special education programs. We know that for determinations, we're using a point-based system, combining the compliance indicators and the results. Indicator 6 is a results indicator that is new for us in the last few years. And you can see the 0 to 1 point. So your district scores 0 to 1 if you're not meeting the state target, and then 2 points, of course, if you meet that 38.3%, so a third of the children ages 3, 4, and 5 receiving those services in that regular education program score those 2 points if you're above at or above that target. Okay, now we'll get to some of the strategies. Okay, so now what? I think that's what everybody's here for. So what I thought about, and I can go through it if we have time, hopefully, a couple of actually specific possible examples, because people are always saying, can you give us some ideas? So when I looked at this and thought about this, I worked with Michelle Agoric, who's our statewide coordinator, and this is a piece that she also trains on to also, are some of those more high leverage pieces, and 5, steps that you can do to start drilling down, and that's really what the answer is on this. And so you'll look at our 5 steps that we have chosen. Just real quickly, and we'll just break these down in just a second. But it's, first of all, checking your accuracy in reporting and coding. And when I say accuracy, does that mean, again, that measurement? Does everybody understand what exactly we're measuring here, and making sure that we're actually reporting this accurately? Number 2, we're going to talk about is where to start. And of course, you're going to see 4K. So when I'm looking at this, where is a good place to start in the district, especially if I've scored, or if our district has scored a 0 or a 1? Where do I start? We're going to talk about that. Where does the least restrictive environment, the LRE process, fall into place? That also is going to be a place that we're going to talk about starting as we break this down. We're going to talk about practices and historical trends that may be barriers to this. And then lastly, resources, tools, and technical assistance. So let's look at accuracy real quick. Go ahead, Rachel. Again, check your understanding, okay, on this piece. A lot of times, I'm just going to say this, but many times directors of special education do come from the high school, middle school world, and don't really, or even the elementary school world, don't have that experience with children who are who go to school in community settings, and how that works with 4K, and how this all works with this indicator, which has, we're going to talk about a two-part process, which makes it a little bit unique. So understanding that, understanding of each of the codes, as you know, we're going to have our decision tree, and we have all those codes that we have to think about, our R1s, our R2s, our R3s, our R4s, our B1s. We've got lots of codes when you break down the decision tree and what all those are. And that piece about errors, you're going to be checking for errors. And lastly, here's the big one, inter-rater reliability. So everybody in the district understands how we're coding kids. And as we go down this decision tree, are we all following the same process during an IEP meeting or when we're reporting in our district? So check for that. The change between indicator 6 and indicator 5 happens at kindergarten, of course. So you're going to want to make sure that as children are exiting 4K, who are 5K eligible, that we're starting to that we're going to go ahead and move on to that indicator 5 piece. So that's where that switch changes to those, in other words, from the R and the B codes to the ABC codes. So that's where that difference happens. And one of the things is know the differences between those indicator 6, those ages 3 through 5, all those R and B codes, and then indicator 5, which is our school age 6 through 21, understanding that it's very different than the A, B, and C codes. So again, using A, B, and C codes for school age and R and B codes for preschoolers. One of the things on those codings is, remember, is the way to think about it. I think the best way, everybody, is with our indicator 5 codes. That is access to, so that really is measuring, do students who are 6 through 21, do they have access, and are they actually in that regular education setting? Are they in that special education, or part-time and full-time? However, with our young learners, our 3, 4, and 5s, we actually have that two-part process. And we want to make sure that everybody understands that indicator 6 not only provides access to a regular early childhood program, we're actually measuring then the majority of the services being provided in that program. And the reason we do that, so I don't know if this helps or not, but if the reason that we have that two-part process is because our children ages 3, 4, and 5 are educated in those regular education settings all over the place. They are in childcare, they're Head Start. They could be in a private preschool, they could be at home. They're not necessarily where our 6 to 21-year-old students who are in school, where we know that once they're in a classroom, that is their regular early childhood program. And of course, for our young learners, it could be lots of different places. So measuring that alone would not be sufficient. And that's why we want to make sure that we're pulling in those special education services in that setting, because we're all, like I said, we're all kind of all over the place on that one. Okay. Number 2, or the measurement differences, right? I just talked about this, right? What is the actual differences? Do those students do they have access, and to what extent, to the general curriculum? And our 2-part question, here it is do children have access, and to what extent do they have access to their general curriculum and their peers? And then part 2 is if they're in those programs, and when they're in those programs, do they receive the majority of those services in that environment? Okay. This is number 2. Go ahead, Rachel. And where to start? A lot of places, I think in Wisconsin, we have the luxury of having universal, what we would call pre-K. And of course, in Wisconsin, pre-K is our 4K programs. We have the luxury that every district in the state does offer a 4K program, whether that's half day or full day. So I always say that is a place to start. So as you're drilling down and you're starting to pull and look at IEPs, start with those children. That's the best recommendation. Start with the children that are already in that 4K program. Here's the good reason is you've already fulfilled the first half of the equation on, are they in a regular early childhood program? So that is a place to start and look at those children. And once we start to pull those kids in, then we can start to look at their, pulling in their IEPs and looking at their services and start to say which of those services can we start to, push into that into that 4K classroom. So that's a good place to start. Children who attend that program, and then start to look at the services and some of the services and where can they be provided. And then from there, what I would say is then look at your students who are already enrolled and eligible for IEP, for special education services in your local Head Start program. You're going to look at who's in your childcare programs, and you're going to look at who's in your 4K community approach programs, because those are your 4K programs in the LEA. So I would start with those first. When you do this, and then if we're going to start, now we're going to go down a little bit further as you start to drill down, and you're going to, what we recommend everybody is start to disaggregate your data when you're looking, and start to disaggregate by age and disability. So if you're going to start, you're going to look at, start with your 3-year-olds. So look at see who your 3-year-olds are and how many you have, and start to ask, where are they? Do you know where they are in terms of their educational setting? So do you know that they're in a Head Start? Do you know if they have access to Head Starts? So ask yourself those questions. The big question, I wish I had bolded this part, is you look and say, wait a minute, are they only in early childhood special education classrooms? Look and see if that, so when you're looking at 3-year-olds, is that sort of an automatic placement for those students because we don't have, let's say, a 3-year-old regular early childhood classroom environment? So look at that and see, are they in those classrooms? And if so, I am going to really just implore you to say, and why is that? Is it for administrative convenience? Or is that really what those 3-year-olds need to be in a full-time special education classroom? So take a look at that and see what your data tells you. See what you observe on that piece. Disability categories. Here's your second piece that I really recommend is go ahead and look at these, specifically these 3. Look at your children who are 3, 4, and 5 who are identified under autism. Then look at your significant developmental delay category, and then look at your speech and language. The reason I say this, everybody, is because our team, Michelle Agoric, has done a nice job with this. They have actually pulled some of this data at the state level, and what we found is, I'm looking at my numbers on my notes here, is that 16% of our 3, 4, and 5-year-olds identified under autism, only 16% of those students are showing pull-out services. So what they're doing is they're showing the majority of their services are pull-out services. They're provided in another location other than regular ed. That's only 16%. For children identified under significant developmental delay, only 17% of those children do we see the majority of their services being pulled out into a separate environment. However, speech language impairment, students who are identified as speech language impairment only, 49% of those students, the majority of those services are being pulled out. So that's why I say take a look at your disability categories for this age. And if you see some of those discrepancies, that also gives you a target subgroup to start to look at on that piece. Okay? Okay. Go ahead, Rachel, because I know we're kind of least restrictive environment. This is a big one. So this is our third strategy, is following that LRE process. What I'm trying to say here is, everybody, is when you're looking at those codes, don't just go right to placement and say, okay, now we're going to go ahead and determine our code. We're going to determine our coding, for this child and decide, are they in an R kid, a B kid, and we're going to look at their placement. No, don't do that. So really what I want you to do, and I did link this in here if you haven't had this, is our the decision tree for everybody. Yes, thank you. You'll be able to see that. And you can see here where you can see, and this is the place to start, is this piece. So if you don't know this, please have this as a cheat sheet next to you to help you go down and ask these questions. So if you go back to the slides, Rachel, that'd be great. But this is in here. So I want to say, so when you're doing this, when you're determining as part of that coding, realize that it starts with, are you ready? It starts with the program summary page. I don't think people have really ever thought about this, that coding starts with that, and that whole idea of that least restrictive environment. So think about, so you're going to be determine where the services are going to be provided. determine what the child needs and what that location is. That's all part of the IEP development. Then we're going to have a discussion around those services. I'm in an IEP meeting, everybody. We're going to talk about the location of those services, and that is what should be driving that indicator 6 coding, or the code that they will be getting. So it's more than just a placement. It's really if you think about this, it's really directly linked to that LRE process. And that's where we end up when we have those R codes, those R2 codes, and whether we should be pull out. That is a result of a very comprehensive discussion through that LRE process. So what I'm trying to say is that's a piece to go back to your districts, especially if you're working in a CISA and you're working with districts. Go back and does everybody understand that LRE process in terms of getting to that coding? Okay. I'm going to let you think about that for a little bit, and we're going to go on to number 4, our 4th strategy. Rachel, go ahead. Practices and historical trends. Think about this if you're hearing this in a district. Do we have, is our practice always, or is our historical trend always that 3-year-olds, when we have a 3-year-old with an IEP, do they always attend an early childhood special education classroom again? Because we don't offer a 3-year-old program. Look at specific disability categories and placement. I brought up the example or the percentage for speech language. So children who receive speech language services, are they always automatically pull out because that's the way it's always been done, or that's working for us? And if it ain't broke, we're not going, we don't need to fix it again. And that's the question to ask in our district. Are all speech language services pull out? Is it because of the clinical versus educational practices and thoughts behind that? Is this the way it's always been done? Do pull-out services, are they working for our district? So these are the practices and historical trends. If you are, and one of the points that came up, if you are, or if you know of, and you're an LEA rep, and you hear some of these questions and some of these answers in an IEP meeting, these are practices and conversations that really need to be changed and disrupted to bring that conversation back to that LRE process in terms of the decision tree. So that's something as you kind of think about as you're moving forward, starting tomorrow. If you happen to be in an IEP meeting or you're working with an IEP team, start to listen for some of these phrases that you might pick up on, and then stop the conversation and say, hey, let's talk about that. And again, disrupt that. So that's number 4. And then we can take some questions. I'm going to give you some examples. And of course, we have our resources and our technical assistance. We've done accurate coding module. If you haven't, that is a recorded webinar by one of our TA staff that's been fairly new, put out. Again, you saw the decision tree, print that out. Make sure everybody in the district understands that process. If they need to, they can have it next to them as a guide as that discussion happens around where should services be provided. We also have on our webpage the Making the Move to High Quality Inclusive Environments, all the different, it's a framework that comes from our Early Childhood Technical Assistance Center. You can check those. And then we also have a guide on determining least restrictive environment for a child on that. I'm going to do one more, and then I'm going to give you a couple of examples, and then we have time probably for a few questions. Go ahead, Rachel, the last one. Yeah. One of the things too, a lot of you, I know many of you are involved with, but if you need anything, you want to make sure you check in with Michelle Agoric and the team around the Early Learning Technical Assistance Implementation Project. Do know that if you've signed up for our email list, that's where all the webinars, trainings, cohorts, and learning series are. And I wanted to let you know that through that request that we have about the TA, it doesn't necessarily mean that somebody's going to come in and really do intensive services. They can come in and provide anything. And then I think, go ahead, we have questions. I wanted to go ahead, the last slide, and we'll just take some questions. It'll be perfect timing for that. One of the things I wanted to say, we wanted to get somebody, a couple of examples that when I'm talking to school districts that I like to give, they'll ask about some of those services. A great example would be, I am a early childhood special education teacher. I'm coming in twice a week. And I'm providing 30 minutes of specially designed instruction to a child on Tuesdays and Thursdays. So if I'm pulling a child out for both of those days, could I not? And if I do change, and if I am providing all the services on Tuesday in that 4K classroom, and let's say I pulled the child out, that's 30 minutes and 30 minutes. I hate to use numbers, but that actually counts. So when you're actually playing a numbers game and you're looking at the time for those inclusive practices, do know that if you have 30 minutes in the classroom and 30 minutes pulled out, that actually counts. The other one I love to give everybody is I'm going to use speech language, again, 30 minutes for a child. And if a speech language pathologist is working on articulation and they are going to work on specific sounds for a child, yes, go ahead. And a child maybe could come out in a quiet area and they could work on that sound that they're going to be learning, in an isolated area. And then what I would say, if you're working on that for 10 minutes, now take that child back into that classroom. And let's say if the child can practice that sound, if they're using it in context with their peers, if they're using it in context with the general environment, you can do some dynamic assessment, you can do some adjustment. And if that's 20 minutes, that's a mathematical equation way to look at this. So if 10 minutes are being isolated, so you can actually take that 30-minute block or that 30-minute time for the special education services, and you can kind of divide it that way in terms of the majority of those services. So those are always kind of some examples. Anyway, so that's about it in a nutshell, everybody, and a place for everybody to start. Do we have, Rachel, a few minutes if anybody has questions?
Yeah, and there are actually a couple in the chat. First of all, thank you for all of the resources and examples.
Yes.
Kind of following up on the example that you just gave, Jen is asking a question related to virtual speech therapy. And as a result, is there a need to code those services as pull out?
It depends. It depends on where, it depends on in that virtual. If I'm actually still, we have seen in a 4K classroom, if that child's in that classroom and they're still receiving their virtual services, that would be your 6A. We've seen that. We've seen the computer. Back when COVID started, everybody, we actually had examples of that. The speech language pathologist sitting, there was a computer with the child, and then a teacher's assistant is working with the child in that classroom while my computer is here. Yes, that still is a 6A, but yes, if they're actually virtual, and they are not with their peers, they're not in that setting learning alongside their peers, that would be considered a pullout. Yes, okay. If they're in isolation.
And the other one I see in the chat is if a student attends a public virtual charter school and the public school environment is in the home, do you use the code indicating the services are provided in the home?
Right, those would be home services. That's a great question. Whoever asked this, we get this a lot. Home services provided in the home, not home. They're really not home based, or they're not really, they're not home school. They are services provided in the home. That is not considered a regular early childhood environment. That's why that was just a few years ago that OSAP created that category on its own, because it's not special education, but it's certainly definitely not at all considered a regular early childhood environment. No, good question.
Okay, that's all I see looking at the parking lot and the chat. So unless anyone wants to unmute and ask Jenny another question, we do have about a minute.
Okay, and I always say this in all my presentations, all of you, you know where to find me. You definitely know where, yes, thanks, Samantha. You all know where to find me. I was just trying to give you some ideas of where to start and how to start think about that drilling down process.
Yeah. Well, thank you so much for joining us and for the great resources. Certainly a great starting point for teams, NTA networks to guide teams. So we appreciate that very much. And for those of you on the call, if you do think of questions as you digest this information or talk with your teams, you're welcome to enter it in the parking lot or ask your RSNs, and we certainly can get in contact with Jenny as well and get back to you. So thank you again for joining us. Those of you on the call, I just wanted to let you know that we are wrapping up for the morning. We've had a super full morning with a ton of presenters and a lot of information. But we want to remind you that we are having one final meeting coming up in May. And let me see if I can find my slides to give you a visual here. let's see. Slideshow. Maybe not. It worked for her. Okay, here we go. So we are meeting next on May 6th from 10 to noon, so a little bit shorter. And our tentative topics are suicide prevention, Medicaid, WISPY end of year, and then we will wrap up our HLPs. So a ton of good topics again. And like I said, just a little bit shorter, but May will be our final meeting for our virtual series. So thank you again for joining us. Have a wonderful afternoon. Happy spring, and we will see you next month. Bye, everyone.